As the streets filled with hopeful protesters, no one could escape the eyes and ears of the secret police. President Assad's vast security machine orchestrated a violent crackdown and conducted mass arrests.
Widespread mass atrocities were taking place. There was no justice and accountability.
There are crimes that are so grave that the whole international community potentially has the right to prosecute them. Under the German legal framework, we have the principle of universal jurisdiction, which allows to prosecute international crimes despite the fact that neither the perpetrator nor the victim are German citizens.
Tomorrow, in a German courtroom, a verdict will be rendered in the world's first trial against a high-ranking former officer in the Syrian regime for crimes against humanity.
Anwar R. is a former Syrian intelligence official. From 2011 to 2012, he was head of the investigation unit of Branch 251, which is also known as the Al-Khatib prison in Damascus. Under his command, allegedly 4,000 people were tortured, including rape, sexual assault, and beating, and 58 persons died as a result of these abuses. He deserted in Syria and then moved to Germany. In his request for asylum, he quite openly talked about his function in the Syrian intelligence and as head of the investigation unit. So in combination to the fact that Germany started already in 2012 with structural investigations on Syrian state crimes, this in the end led to the arrest warrant in 2019. The trial opened in 2020 at the Federal Court of Koblenz. Anwar R. was initially charged with crimes against humanity, including killing, torture, and different forms of assault. And he was charged with domestic crimes under German criminal law, including rape, sexual assault, and 58 counts of killings. The federal prosecutor, in its initial indictment, assessed sexual violence as a category of crimes that were not part of the systematic crimes committed by the Syrian government. In contrast, they were charged as crimes under domestic criminal law of the German legal framework. This is a wrong legal assessment, which is not precise, because it lets out the systematic dimension of sexual violence as part of torture and different forms of abuses. And then the civil society organizations, so we as ECCHR and lawyers and joint plaintiffs, we jumped in, filed a motion requesting to amend the charges of crimes against humanity with charges of sexual violence like rape and not as isolated acts under German criminal law. The heart of the Al-Khatib trial was the testimony of 80 witnesses, including survivors. Several civil society organizations supported the survivors during the trial, including the European Center for Constitutional and Human Rights and the Syrian Center for Legal Studies and Research. 17 joint plaintiffs were present in the trial, represented by several legal counsels.
For a case with so much sensitivity, it was very important to show that there was societal backing, that there was organizational backing that encouraged survivors to come forward. Survivors of sexual violence, and in particular female survivors, face a lot of barriers in their ability to access criminal accountability. There is a lot of social discrimination that they face. and there's a lot of trauma that they have to deal with. So because of this reason, a group of feminist civil society organizations decided to form a coalition that would help advocate for comprehensive support to the survivors, be specialized services that included psychosocial support, also measures that would be able to protect the identity of these survivors, to encourage those that are more vulnerable to be able to participate.
In an international proceeding, you go far beyond than the individual crimes, which requires to have experts that are drawing attention to the motivations, the policies, and the strategies of the Syrian regime in this case. And that was the reason why it was so important to have not only witnesses of the relevant crimes, but also experts that could really tell more about the broader picture of these crimes. For example, we had a pathologist who presented his analysis of the so-called Caesar files. More than 27,000 photos of deceased, killed and tortured persons, amongst them victims of the Khatib trial. He explained in his analysis how these marks of torture on the bodies of the corpses confirm the techniques of torture they were presented by the survivors of the case.
So we're going to start with some breaking news out of Germany. The first ever conviction for crimes against humanity for a former Syrian government official. A German court has sentenced Anwar Raslan to life in prison.
So the verdict was delivered on the 13th January 2022, and Anwar R. was convicted for crimes against humanity, including killing, torture, deprivation of liberty, arbitrary detention, and sexual violence. Also, he was convicted for other crimes under German criminal law.
The Al-Khatib trial was the first worldwide trial that addressed Syrian state sexual violence and torture committed in government detention centers.
It was quite important that in the end, the trial was able to show that sexual violence was part of the systematic and widespread oppressive system in Syrian detention centers, and that these crimes normally are not opportunistic crimes and not isolated crimes. And I think the lessons learned of this case should be that future criminal proceedings, sexual violence should be precisely and legally assessed as part of crimes against humanity. I think it's always quite important to include civil society organizations in international criminal proceedings. For example, the legal motion of the joint plaintiffs and civil society organization led to amend the charge by sexual violence as crimes against humanity.
The Al-Khatib trial was a very important opportunity. These survivors of torture, of sexual violence, of other heinous crimes committed in these detention centers, to really be able to participate in a trial and to put forward their testimonies and to be able to face the perpetrator. For a society that had had so few opportunities at justice and accountability, this indeed presented a unique and important opportunity. What this trial did is that it made a ruling that said that these crimes are crimes against humanity. It's not just about individuals. Society was affected. it really gets us to address the crime and the root causes of the crime in a much more comprehensive manner.
The future of international criminal law is domestic, because we see that national jurisdictions are capable to deal with international proceedings. But that affords that they incorporate this logic of a broader understanding of justice. International criminal justice has really its future before national courts, and we are fighting for this.